There's no shortage of commentary on the Arizona law and on SB 1070, and most people are predicting that the court will grant cert for reasons that seem obvious and compelling. Not only has the Ninth Circuit enjoined a law or upheld the injunction of a law, but other states have followed Arizona and enacted their own laws. My home state of Georgia has, Alabama has, Utah has, Indiana has, right? And in each of those cases, courts, well, except for Alabama, in each of those cases, courts have enjoined the enforcement of the act on the doctrine of preemption. Alabama has stayed its decision while it further studies the question. So no court has upheld one of these statutes. The National Association of State Legislatures, National Council of State Legislatures reports that over 30 states have significant immigration legislation pending, and so there's an obvious need for guidance here. The one caveat I would offer is that this involves a question of preemption, right? The issue in these cases is not racial profiling. A lot of public discussion centers on that, but the issue in these cases is whether or not these laws are consistent with federal statutes. And the court might well think that Congress is going to get around to addressing this issue, and it's Congress that ought to be providing the guidance. So with that caveat in mind, that the court might decide to sort of sit back for a while and see if Congress does anything. The other factors would seem overwhelmingly to indicate the court ought to take a look at it, in which case I think this is a case that comes down to Justice Kennedy. And I think it's hard to know in advance what he will do. He has been sympathetic to preemption claims in the past in a way that would make you think he would be willing to side with the Ninth Circuit on at least some aspects of Arizona's law. On the other hand, he's, as he has in so many areas, gone both ways, so it's apt to be a close argument.
One quick question. Could you identify what the precise preemptive aspect of federal law is that is said to be operative in this case?
Right, so there would be two. There are two types of provisions of the Arizona law that have been challenged. One would be law enforcement. One set is the law enforcement provisions that authorize state officials to, in essence, enforce federal immigration law. The other set would be new crimes in the state of Arizona crimes that are based on federal immigration
But I'm
infractions.
asking for the flip side of that, which
And
is
so the
what's the federal
right,
preemption?
So the federal preemption would be that with respect to the law enforcement provisions, there is a federal law that dictates how it is that the federal government and states are to cooperate. States apply to the Attorney General designates them, chooses officer by officer which officer will be authorized to enforce federal immigration law, and it's all subject to the Attorney General's supervision and control, which ought to appeal even to a justice like Justice Scalia, who thinks it's a violation of separation of powers for Congress to vest local law enforcement officers with authority to enforce federal law. So, you know, why wouldn't the Arizona law fall under that? That's a separate argument from preemption. The preemption argument is Arizona is going around that system of having the Attorney General specify the officers and directly authorizing their officers to go ahead. With respect to the criminal provisions, it's simply a matter of federal discretion as to how to enforce federal immigration law, which is complicated by the fact that you're introducing local state prosecutions.
That's why I guess the question I want to ask is that it seems to me that for reasons that we don't have really time to get into, actually both aspects of the problem really do involve a claim that the preemption flows from the interference with the discretionary authority of the Attorney General over the enforcement of the immigration laws. And in order to make that stick, and I do concede that the case law is that a federal policy may have preemptive effect, but doesn't the administration have to say that the current level of enforcement of the immigration laws, which is to say whether you think of it as lax or just right, is a federal policy, and that therefore additional enforcement of the immigration laws to,
No,
bring
I
people.
I don't think that the federal government has to say the current level, at that systematic level, is where it's supposed to be, but rather that case by case, the Attorney General has to have discretion about what to do with a particular alien.
Sure, but
and if the state is
But the state law
interfering-
says you bring him to the feds, right? And so at that point, the AG has the discretion. So if there is in fact a
Not the
preemptive
provisions
effect,
of state criminal law, which say throw him in state jail. And that might not be the disposition that the Attorney General wants with that case.